besides us just switching cars and speaking. That's just not okay.
Okay, so why didn't you just apply it then? If you know what the solution is, why don't you just perform it?
Because I saw
on Zoom as well.
So, Your Honor, to respond to a number of things. First of all, the issue that's now being raised is suggesting that the 3 days a week of in-person visitation plus the effectively unlimited contact that we, engage with on talking parents is somehow a sole custodial arrangement, which under Roe v. Roe is the standard is no significant parenting time. It certainly is not the case. Moreover, we're in a supervised visitation position because the parties agreed to it. And the court was right to observe the problems that of the parent, and while the representations have been made that Mr. was waking up on May 4, I just checked the timestamp of that communication. 4:43 p.m. He wasn't waking up in the morning. If he was waking up in the afternoon, that's certainly a cause for concern. That certainly wasn't disclosed. Okay? So the concern about these things, okay, that the court observes is real. And I will apologize to the court. My client is nervous. She is worried because when she starts to hear that somehow this custodial arrangement that he agreed to, by the way, he's agreed to every single custodial order in place. Right? This is something where there's been a trial and it's been resolved. No, every single custodial order has been what he agreed to. He will agree to a situation where he's required to make sure that his doctors are in touch with one another, has a prescription diary, a prescription journal, right? That he would make sure that he communicates to his doctors about any side effects. As the court observed, fairly conservative requests, right? These agreements aren't something onerous where, we come back and we have to have some sort of evidentiary hearing. No, for the most part, it was make sure he's healthy, make sure his doctors are aware of what's going on. Putting them in touch with one another only can help him. It can't hurt him. In response, we get, well, it violates my HIPAA rights. Excuse me? He's got the right, okay, to say, yes, please talk to each other. That he won't certainly is concerning this court, especially in light of the agreements. But ultimately, what we're here today for isn't a rehash of what was already stipulated to. It is a contempt matter, okay? And the concern about supervised visitation and the rest of it, okay, is one which is not properly before the court, especially in light of the stipulation, right? And when the court considers the fact that, as Mr. admitted, he hadn't seen his daughter on his own time for 3 months, over 3 months. Certainly, if there was a legitimate basis for my client to be charged with withholding, he knows where the courthouse is. This dispute started originally not because my client filed a motion for murder show cause on October 11, 2023. To the contrary, it was Mr. frivolous motion for murder show cause filed 1 week earlier on October 4, 2023, to the point that it was so frivolous that despite the fact that Judge Duckworth said that he had made out a prima facie case and it had the right to submit for a murder show cause, chose not to. To the point that Mr. Willick, which I will tell you was a first in my experience, had said perhaps we didn't do our research enough. Perhaps we didn't investigate enough. He actually used the Rule 11 reference. So that was a reflection of the quality, or lack thereof, of the position that was being taken by Mr. for those allegations of withholding. So when we look at this, right, this is not about should he get supervised visitation or not. That's been agreed upon. Okay, the court is right to observe, he didn't look all right on May 4, 2024. And we don't have the evidence that he woke up at 8:10, we had this phone call at 8:30. To the contrary, it was 4:43 p.m. is when it started. Wearing a robe, no shirt. Those are the matters that the court would resolve if there's going to be dispute down the road with not only proper briefing, but certainly a better heads up than let's talk about some issues as opposed to this is all of what we're dealing with, which is a contempt matter. Okay, the court is always right to figure out, is there some change in things? There hasn't been. Okay, yesterday, good example. Okay, there was a request. Can my client see, or can my client's mother see? This was last Thursday afternoon after we had our calendar call, and I said, excellent. I will speak to my client. I email 11 a.m. Monday morning. Friday's no good because we have people coming into town. Okay. I understand that maybe defendant's mother has not seen the child more than twice before yesterday. Okay, so there was visitation yesterday. Okay, my client said, it can't do Friday, but can we do Thursday if we do the supervisor? Did Mr. arrange for a supervisor? No, he didn't. He didn't do it at all. And as the court is right to recognize, okay, this isn't a case where the supervisor, okay, is there to protect perhaps some violent attack. Right? That's not the real issue. The issue is he unsafe? Or perhaps, is he going to say something that's inappropriate? Now, the court has seen exactly what we're living with. His mother is not the neutral person who would tell the truth. Right? His mother isn't the person that would tell on her own son. So it wouldn't be the appropriate supervisor. And so my client said, fine, let's have some frozen yogurt. There was a deadline concerning a leak in her home, so there's a bit of a compressed time period. But at the last minute, she made it happen. This isn't a situation in which he got the short end of the stick. He did better than what he ever would have had she stuck to her guns and said, you didn't get a supervisor, you're not getting time. She went out of the way to make sure they had time.
Was Dad there as well, or?
Yes. It was. So this is correct. I mean, like, it's certainly not convenient at the last minute to say, can we do this? She bent over backwards to make sure it was there. Okay? The idea that she wants to, hide, conceal, keep away. To the contrary, my client wants a life judge. She wants her to have a great relationship with her dad. Okay? And when your court observes that she has such a good relationship with dad, that's a credit to her. I mean, she's doing what she needs to do. That even if they're having problems with communications, she's not letting it infect the relationship with the daughter. To the contrary, we see, or conversely, we see what Mr. is saying to this little girl. And were we to put on all the evidence, the court is going to see that there were continuous violations in December. The court's going to see the violations in January. The court's going to view the videotape. Okay? But the arrival at an agreement concerning the communications coordinator, okay, I believe has given them license to say, let's revisit visitation generally. And that's not only not before the court, okay, but it also wouldn't be in the interest given what the court has observed today and the misrepresentations that have been made to this court about when that May 4, 2024 communication actually occurred.
To be clear, counsel, because I don't want you to continue to use your time for this, we're not revisiting it.
Okay.
And as I said, if anything, I have more concerns today than I had prior to today. And that's it. I'm going to continue to honor the agreement by the parties until we conclude evidence on this matter, unless you all reach other agreements that I'm certain I would adopt if you find other agreements in the best interest of your own child.
Excellent. And now we're ready to proceed with putting this in the witness box.
Your Honor, I have to respond to what Mr. Jimmerson put on the record here, and he said that Mr. Willick said he hadn't done his Rule 11 investigation, and they said he hadn't done that because he had just gotten on the case. I reviewed that video of Mr. Willick doing that. Now, there was an order that was filed February 27th, and that order stated that Dad has entered into an agreement with mom concerning certain parameters for his mental health treatment, temporary custodial limitations as enunciated in the February 2024 email from Mr. Jimmerson and Ms. Allison. A copy was supplied to the court. The email requested.
What page are you on, counsel?
I'm sorry?
What page are you on?
I was on page 2 of that.
Okay.
And that has to do with, on page 2, line 9, regarding temporary custodial limitations. The operative word there is temporary.
Of course.
So that is important here, that we understand that that is just temporary. Now, as to the visitation, Mr. Jimmerson, we did talk about after the pre-trial conference about Dad and Grandma having some time. And so I spoke to my client. regarding visitation. Says his client has already made plans with someone coming into town. I don't think that takes precedence over grandma. However, she can offer time with Thursday before 3:30 p.m. to 6:30 p.m. provided that a supervisor with Mr. Mother and Mr. pick up her is one to pick up thereafter. I then responded to Mr. Jimmerson a couple of days later. Says Mr. Jimmerson, his mother will be in town tomorrow and would love the opportunity to spend time anytime she can with mother. Could be the supervisor. That would allow for a better bonding experience between the grandmother. There should be no question that she is a perfectly safe and appropriate person to be a supervisor for the child. When my client went to end up meeting to pick up the child from Ms. she wasn't there because rather than making the child available at 3:30, the child was in day camp, meaning she had to go pick up the child from day camp. She'd be late in coming back, and then also she managed to have a plumber have work being done at her house. So the best that they could do was meet at Yogurtland at Lake Mead in Tenaya for about 10 minutes total yesterday before she had to leave and take with her to go back and meet with the plumber. I would submit to you that is conduct. We're talking about conduct here before she had to interrupt the proceedings here. That shows a marked disinterest in promoting a relationship between dad and child, between grandma and child. That's the best we can do is give 10 minutes and conclude that grandma is unqualified to be a supervisor for this 5-year-old child. You know, they talk about the child not knowing grandma that well. Okay, well the child doesn't know the supervisors very well either, but she's sure okay with the child being around supervisors that she doesn't know very well. You can't pick and choose what you want to have, you know, around your child like that. I mean, for example, they didn't want her.
Mr. Page, for the sake of time, I don't know where we're going with this. If there's a request, certainly I wasn't privy to any agreements outside of court regarding visitation. I'm not going to make any judgments about what happened there. It sounds like there was a visit, even if it was limited. I hope that the parties can agree on more visits in the future. But again, we're here for contempt, not to readdress visitation, and I would like to continue, because we're continuing, your client needs to return to the stand, because we're in plaintiff's case in chief.
I appreciate your latitude and give me the opportunity to put our side of the record on there, because Mr. Jimmerson placed some things on the record. I want to make sure that we filled in the record as well. I appreciate that, thank you.
Of course, Mr. Page. Sir, will you please return to the stand? Noting the long time of our break, we're almost at 4 o'clock. If you could just stand, sir. Madam Clerk, if you can swear him in again, and then we'll resume.
Please raise your right hand. You do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, under pain and penalty of perjury.
I do.
And you may be seated.
Good afternoon, Mr.
Good afternoon.
Did you testify truthfully when you told the court that you were just waking up?
Just waking,
I'm not done with my question. On May 4th, 2024, just prior to engaging in the call with,
yeah, Leah's waking up from a nap. Take naps. Sorry.
Your Honor, we would like to move Exhibits 61 and 62 in evidence. They are Mr. prior financial disclosure forms filed.
You should be for record.
61 and 62. 61 is the FDF filed on April 22, 2022, and 62 is the FDF that was filed last year on December 6th.
Thank you, counsel. Court record 61 and 62. In.
Okay. Mr. Pastor, can you please bring up the video, which is Exhibit 47? Can we start at 7:50? We move ahead to 7:50. It's been admitted evidence, Your Honor.
Yes. You're sharing audio, right? 'Cause I'm not hearing anything.
Sorry, that was mine, but if we need to use mine, I'm happy to do so.
Sounds louder.
That's why we brought it in, Your Honor.
Did you hook up speakers?
I did.
Let's do
Can
that.
we just, Mr. Pastor, just click on 745 and we'll hit play together? Are we at 745? Sorry, I can't see. Okay, we'll hit play because ultimately the visual is probably less important if it's on, it's queued up than the audio. Can we press play now at 7:45? 3, 2, 1.
You can stop taking her out of school 30 minutes early just to create You can hear me. Oh, let's take her out of school to create a toxic exchange. And then when you give her an answer, oh, I can't hear you. I can't hear any acknowledgement of my custody order violations. I don't know what to, here's an idea. Don't take her out of school early in violation of the custody agreement. Bring her here and just let her father pick her up, which is something she enjoys. I can hear you, son. Sure you can. All exchanges like this. All exchanges. She forces 2 extra exchanges that are toxic every week, including the one where she perjured herself 2 times to try to force drug tests that showed nothing. This is constant, not unhealthy and unnecessary. I wasn't early. So you can hear me now. You couldn't hear me before when I pointed out your custody violation? Yeah. So I recorded the moment that I arrived, and that is recorded, the timestamp, and it was not early. So do not lie about me or instigate toxic exchanges in front of our daughter, okay? Who initiated the speaking? Was it me or you? I have an idea. Instead of picking her up early from school and then bringing her here for situations like this, you could just just waterboard her at the school. That way you get to torture her there and she still gets the joy of me picking her up, you know? It's an idea. Right? I mean, hey, that way it's a compromise. You get what you wanted to do and I get to pick her up. Yeah. Don't approach my car. Cool. So I'm gonna pull away. There you go. Away from my car.
It's still on my property.
Hey, halfway?
Please
No.
don't call me names in front of our daughter.
No. Away from my car. Away from my car.
Just park.
Away from my car.
I'm on my property.
Away from my car. Away from my car. Away from my car.
Please
All right.
don't call me half.
Mr. Pastor, can you bring up Exhibit 46 as well? We're going to go to that next. Before we do, though,
Well, let's try this again.
your statement to my client in front of you could just waterboard her at the school. That way you could torture her there. That was a violation of the behavior order, right?
Absolutely. Troublesome one too.
What's so troublesome about it?
That when I see in such distress, and I felt that she was being put in distress by this for a confrontation that unnecessarily, when that I wasn't able to control myself as I had been doing at that point. That is very disappointing to me, and it's shameful. And I should have just shut my mouth and just.
You were on a roll already, though. You're already talking to yourself about toxic exchanges and the rest of it beforehand, right?
As a narrative too, this is something that I believe my former attorney brought up since the first exchange where your client claimed I was on drugs and proved to be perjuring yourself. And the positive parenting class I took, which I believe we went over at the deposition, if I'm not mistaken. And the positive parenting class said clearly, exchanges are the most emotional thing for a child. You cannot have, you need to try to eliminate having the parents involved in exchanges, having them in emotional places, like in front of the house, or in front of a police station if there's a parenting coordinator involved. This is part of the positive parenting classes I took after our first hearing, and this has been brought up to you multiple times, sir. And this is just exhausting and very hurtful to see these exchanges being toxic, and my daughter seeming really psychologically damaged by them.
What responsibility do you take for this so-called toxic exchange, or these toxic exchanges?
Both, I'd say in that instance, once I opened the window, I should have simply been quiet and shut my mouth, and that is, I wish I hadn't reacted.
That wasn't my question, sir. What responsibility do you take for these so-called toxic exchanges?
After requesting they don't happen anymore, and you're insisting that they continue since November 8th, again and again through counsel, through two forms of counsel, that they don't happen anymore, and yet you keep insisting that they do, I would say we are both responsible for not solving this sooner, because this is not acceptable for her to be going through that. As the counselor told me, she's going through something where she's saying goodbye to her mom, and she's going to go to her father, and that's a lot for her to take in already. She's in front of her home. She's going to go to her dad's house, and then if there's anything besides us just switching cars and speaking, that's just not okay.
Okay, so why didn't you just apply it then? If you know what the solution is, why don't you just perform it?
Because I saw speaking, saying negative things, trying to provoke me with seeming crying in this really odd state, conveniently the day before a deposition, just like convenient. And
Sir,
yeah,
you came to the exchange amped up, right?
amped up? No.
How would you then describe your demeanor
I would
before
say-
rolling down that window?
I would say it's similar to your demeanor to me now. I am sharp in my language. And I wish I wasn't, because it seems different than how I actually feel. And I would say I get there when I see and I've been trying to get counsel to stop these exchanges. I've been trying to arrange it so that I can pick her up and we are not involved in these exchanges for months, and I see her. And now I'm starting to think, why do I even live here anymore? Because she's just literally, clearly the conflict is affecting her psychologically. I'm trying to be here in her life, and it's not helping. That's really emotional and difficult for me to look at, and obviously, unlike the way I'm showing myself now, I was just sharp, and I should have shut my mouth because that's not okay. That's not a way to deal with conflict.
Why did you even contemplate, why do I even live here right now? Why do you even ask yourself that question?
Because I talked to multiple counselors, and I said, listen, this conflict doesn't seem to be getting better, and no resolution that I've put forward, parenting coordinator, anything to stop this conflict is being accepted, and it's now been years, not just 2023, where after suffering immensely, and I'm not handling it well, and I'm seeking the counsel of trying to better my behavior about that. But now I see that the conflict is affecting me to a point. I asked 2 different counselors, one of them being Nicholas Ponzo, when he gave me a report. I said, can I stop you for a second because he worked with the court? Let me ask you a simple question. If a child, when they grow up, is trying to get away from trauma, from 2 parents conflicting, and do they care whose fault it was? And the answer from both counselors was no, they don't. I don't want to be a part of the problem. I live here away from my family, and I spend every money I've had, every dollar I've had for 2 years just to try to be there for her for a minimum of 11 hours a week. And I see her deteriorating mentally, so excuse me if I'm like this. Sometimes I'm a bit sharp like yourself, and I know you're trying to defend your client, but I'm just.
Well, I'll give you a question, ask you another question, okay? You brought up that there needs to be fewer exchanges, all right?
Yes,
Okay,
because
no,
it's
I'm,
too
again,
emotional
please,
for her.
we're trying to
She
move
can't
this,
deal
move
with
this,
it. She's
move
not
this
dealing
along.
well with it at all.
Yeah, so here's a great question, okay? My client in January, I think it was 3 weeks before this exchange, offered to allow you to pick the child up if you were to give, I believe it was like 60 straight days of on time and complete visitation, so that she would be able to trust that you would be there to pick her up at school.
I'm sorry, say that again?
3 weeks prior to this, my client had offered you the opportunity to start picking up the child had you gone and demonstrated a pattern of consistent on-time pickup, because the year prior you hadn't been on time or consistent. Wouldn't that be a fair statement?
I'd say that'd be an unfair statement. I'd say
Isn't it true you exercised less than 50% of your visitation in 2023?
that's completely false.
Oh, what was the percentage then, sir?
I don't know the exact percentage, but I do believe.
Give me an estimate.
I would say everything before the stipulations with Michelle Hauser were canceled, and I had to move back all of a sudden, try to find housing, and then started picking her up. I would say from July onward, 100%, and before that, with the stipulations from Michelle Hauser, if those are counted, which they should be because they're stipulations we agreed on, 100% of those. In fact, the only reason they stopped is because April 24th stated that she was no longer going to accept the stipulations, so I drove 12 hours to see 4 hours, 5 hours, and stayed here overnight just because I was concerned for her health. And when I told your client, I'm concerned for her mental health, she's not seeing me enough, she said, send me some video in exchange for proof that she's having problems, and I'll let you have a couple of hours with her. I was like, are you kidding me? No, what are
Mr.
you
Jeffrey.
Trafficker? And that's where that term came from.
I just want to make sure I understood you, okay? You said that you exercised 100% of visitation from July on?
I think you said that to the court yourself, sir. Didn't you say to Judge Duckworth, has never withheld and he's made
No, I'm asking whether or not you just testified to this court that you exercised from July 2023 on, to the end of the year, at 100% of your visitation.
If it, when I was in town, if I didn't have to make it up, but I would say at around when I started being concerned about.
Sir, it's a yes or no question.
100% since July.
That's false, you didn't.
No, I took 2 trips.
Mm-hmm. So when you said it was 100% since July, that wasn't accurate either.
They were made up. They were planned. Mr. left town.
Okay.
Is that is
I just want to make sure we're on the same page in terms of what the accurate test.
more than I did.
Okay. So, but even if you were to give you 100% from July on, that's still 6 months.
That would be inaccurate, because she left, she didn't give me visitation, make up
Sir,
time.
I'm going to remind you again, just answer the question asked, it's not tit for tat. You're being asked the questions about your actions.
Before July, certainly wasn't 100%, right?
Before July. June was,
The first, January through
we
June.
weren't sure what the stipulations were anymore in June. We were arguing about them on Talking Parents.
Okay, so you made sure that you followed the old rules then? You made sure you were on time 100%?
I didn't know what rules applied. I kept.
So you just didn't go? You were actually living in LA, weren't you?
In June, no.
No, in between January and June, you lived in LA, isn't that right?
No, I was still here.
You never lived in LA between January and June of 2023.
My lease in Las Vegas ended February 28th. So there's no way, I don't understand.
It's a yes or no question, sir.
Between January and June, that's inaccurate.
So you lived in Las Vegas, or excuse me, at no point during that date range, that 6 month range, you didn't live in Los Angeles.
That 6 month range is inaccurate. In
I'm
February,
asking, at any point during
I moved
that
to
6
LA
month
in
range,
March. On February 14th, your client and I agreed on a stipulation for my visitations while I would live in LA, and I followed those stipulations.
100%?
Up until she canceled them, yes.
Okay. Notwithstanding that, you had an opportunity to reduce the exchanges as you complained about, and you didn't accept it, did you?
Reduce the exchanges?
Yes, you were given an opportunity if you had demonstrated consistent and on-time pickups for a certain period of time. There was an offer for you to begin picking up school, is that right?
In January?
Yes.
Was this the offer that you made instead of following Judge Duckworth's orders to? I'm not sure what you're referring to. Can you be clear? I don't see.
Isn't it true that you were offered the opportunity to begin picking up from school after you had completed a certain number of days of
I've
on-time
never
full
heard that
pickups?
offer. So if you could show me the exhibit, I would be happy to confirm.
I didn't know that you were in it. I didn't know you were going to bring this issue up, so I don't have it. But I'm happy to bring it up to the court.
Please do.
And I'm happy to show everyone that that's what it was.
Please do.
Okay.
I've never seen it before in my life. I never heard that. I do know that we were under court orders of Duckworth. Sorry.
Can I show opposing counsel? This is page 3 of the letter. January 3, 2024, he served. Yeah, January 3, so even more than 3 weeks before.
So you're gonna pick up and drop it from school or just pick up and drop?
Oh, it's actually an increase.
No, the location, school or?
It would be school.
School.
Do you see it?
I'd like to see it.
Yeah.
Again, I have no faith in Thank you.
We'll mark this as Exhibit 135, Your Honor. Yes, I know.
Yes, I remember this, the letter to renege on your agreement with Judge Duckworth's orders.
Okay,
Yes.
so I then can take my computer back because you do remember it.
But I did not read all of it. I just read the top of it and said, so, Attorney Allison,
You obviously knew about it and you didn't accept it, isn't
no,
that
I
right?
didn't read the whole thing, no. I didn't read that entire document.
Sir,
I talked to
I'm-
Judge Allison. And
okay,
she said,
and
they're not gonna give you more time with your child, we need to file a custody motion. That's what you told me.
so certainly you responded then, either through counselor directly, with some sort of counteroffer if you didn't think that the 90-day expansion of visitation was appropriate, right?
90-day expansion of visitation.
Yeah, there was an offer basically saying put together a track record in 90 days.
It
That's the
already-
appropriate time to begin the expansion of visitation.
And it had already been over 90 days since your first time you offered me this in September.
Sir, it required 2 things. 100% exercise of on-time visitation and compliance to the behavior order. You didn't comply during those 90 days, did you, sir?
I do believe I was 100% on time with visitations.
Certainly you weren't compliant with the behavior order,
So
were you,
you
sir?
wanted 90 more days of exchanges in front of the house, and you're confirming that? And that we're clear?
No,
and
sir.
toxic?
What I'm confirming is that you had, pen in hand, the opportunity
to
eliminate these things, and you still chose not to,
hand in
right?
hand the agreement to continue for another quarter of a year that exchanges that I believe shouldn't be taking place at all and have been instructed by counselors that are toxic for children, which is
You mean the
exchanges-
same?
Excuse me, exchanges in front of the house, which has been stated by multiple counselors as being highly emotional and something that children should not do in exchanges when there is contested issues with parents. Yes, I did not agree to that being a healthy thing for my child as per the counseling I had undergone under our agreement with Judge Duckworth.
You're not willing to wait 90 days so that you could do this? I'm not done with my question, sir. You're not willing to wait 90 days?
I'd already waited 90 days.
I'm not done with my question, please.
Sorry.
You're not willing to wait 90 days for the potential expansion time, but you're going to simply go 90 days on your own without exercising any visitation?
I'm not willing to trust your claims and constantly get goalposts moving and me expanding time with as though as an excuse to just agree to not file a modification of custody and then subject my daughter to more of these toxic exchanges by parents who are highly conflicted.
That's fine. We're going to move on to Exhibit 46. We're going to begin, Mr. Pastor, at 2:20. This is continuing on with this exchange, Your Honor. Sorry. I need to plug my thing.
Starts at 2:40.
No, we're starting at 2:20. Right, the tape, we're starting at the time stamp of.
Evidence of what? You understand? Let's both submit it to the court. We have a status hearing, we have a trial motion. Yeah. Oh, you mean like,
So much.
I don't know.
I love you so much.
You mean like exchanges in front of the curb and being on your property, things like that? Yeah.
It's Baba's day and I won't pick you up with Baba, so let's both put our phones down.
No.
And you go with Baba.
Never putting my phone down.
Mr. Pastor, can you please cue it up? I'm happy to turn around. We're seeing nothing but concrete.
Yeah, but there's actually, if you play this, there's movement.
Yeah, no, but Mr. Pastor, can you please cue us up to 3 minutes?
Yes, you just have to tell me when to.
Yep, we're gonna start in 3, 2, 1.
I know exactly what you do in order for the topic.
Do it for the topic exchanges that you mandate. Well, hey,
Put my phone down and ask.
why do you take her out of school early?
What are you talking about?
Oh, you don't know what I'm talking? Oh, okay.
This is called parenting.
Oh,
Please.
abusing a child is called parenting? Release her right now. I'm calling the police. I'm waiting for a squad car. Full stop. I'm waiting for a squad car, but she's under my arms within 45 seconds. I'm not kidding. I got you. Honey. Come here. Okay. What's wrong, honey? What is it? You don't want to have a Baba Day? Is it because?
It's Baba Day.
Is it?
I promise I'll pick you up at 6.
Is it because of the argument? I understand.
I'm sorry, Baba. Arguing's mean. I'm sorry, Baba. Do you have anything to say?
Yes, let's go through the transcript and see who initiated
Can
it.
you say sorry too, so she knows there's no fighting?
I can get my daughter away from a person who I think has some issues. That's it. Yeah. Why don't you just keep doing this to her? This is really healthy at a tender age.
Stop.
Yeah. Destabilize as much as I can. Please let her go. I told her 45 seconds or I'm calling the squad car. Okay. Okay. So I'm gonna call the squad car. I'm waiting here for a squad car. We're done. Sure. I'll be filming until the squad car arrives. Yeah. Hey, honey. I'm sorry you had to witness that. You didn't have to get called that. I'm sorry. I'm sorry. I'm sorry. I know you do. You want to give her a hug? hug before we go? Is it because of the argument? I'm sorry. I'm sorry that you started that argument. She shouldn't be doing that. I'm sorry. Were you really sad before the argument? You want to give her a hug before we go? Okay.
Best time ever.
What was the unnecessary statement before she was released? Stop coming here early. Good day.
Stop funny when you laugh at people hurt.
Well, your mom is just funny.
You can laugh at people when they're hurt.
I'm not laughing at you. Trust me, mommy's not hurt. She wanted this. And, that's why she took me out of school early. Come on.
How many violations of behavior do you think you engaged in that 5-minute sequence?
In terms of talking to the child about the mother, I would say at least 7 to 12.
You said that he was in distress, and that was some sort of justification for what you did. Do you remember that testimony?
I didn't justify anything I said. I said it's completely shameful and I wish I would have shut up, and that's not
But
justifying.
I'm going back to your testimony that distress. Right?
Absolutely.
Isn't it true that crying at the beginning? Right? We started this clip at 2:20, so you had another 2 minutes beforehand. She wasn't crying. She then started crying approximately 1 or 2 minutes in, right?
She was in distress before, sir.
How?
You didn't see the video. I walked up and saw her. She was in distress. It was absurd. It was upsetting. I don't know why, but there have been a couple of pickups like this.
Okay, so if you don't know why are you getting angry at my client? Why are you getting hostile with her? If you don't know why distress, why can't we have an engagement in good faith? Perhaps she's angry at what happened, at school. Perhaps there was something that's completely unrelated to either one of you as parents.
I have not said once that that was appropriate, and I feel like you just keep wanting to imply that was appropriate. I'm upset that Ms. is attacking me for coming early and starting a conflict while she is clearly emotionally upset, and I've said again, and the exchanges being toxic this way doesn't excuse me not shutting my mouth. That's what I've said, I think 3 or 4 times, and that has not changed. I don't know why you're putting words in my mouth, sir.
I'm not putting any words in your mouth.
You
Okay.
said I've justified things. I did not.
Well, then what's the purpose of adding the additional language then if not to attempt to justify or defend your behavior?
There was no acceptable purpose to not controlling impulsive actions about something that seriously emotionally bothers me about these exchanges.
But you
Not
weren't
thoughtful
crying
actions.
up here, right? We don't see you crying. We see you angry. Isn't that right?
Mr. Jimmerson, I don't see you crying for your client. That doesn't mean you don't have a sharp tone when you're defending her because you care about her. I get a sharp tone with you. Sometimes I get upset. Are you claiming that I'm faking it and that I don't care for? I can't ask the question. I'm not. If you're claiming that I am faking it and don't care about my daughter, I think you are missing the fact that I've dedicated every resource and every ability I have for the past 3 years to just be around her, less than some babysitters.
Then why do you miss so many visitations? Why do you miss so many visitations?
According to
That's
you.
his first testimony.
Ms. State's prior
He
testimony.
said he got 100% of his visitations. That was his testimony.
Except for all the trips.
So there were 2 trips and there were makeups, so we didn't miss.
So you've not missed any visitation. Is that your testimony?
I think it was your testimony to Judge Duckworth that Mr. never missed any. That
There's a
he has not
difference.
missed any.
There's a difference between Mr. not withholding visitation and you waiving it.
I've never waived any visitation. I only get 11 hours a week.
Okay, I'm just going to ask you a question. Bring
That's
it
the
on
only
here.
reason we're here.
October 3rd, 2023 is a Tuesday. That's a visitation day for you, right?
Mm-hmm.
You didn't exercise it, did you?
No.
You were in town, weren't you?
I was.
What were you doing on October 3rd rather
In the
than?
court office because you're after responding in a professional manner to your stipulations that I see here, 1 overnight a month for the next 3 years, and I can't litigate. Ms. started being antagonistic and then left town with denying my visitation. Please don't do this. Just give me makeup dates, but you have to stop doing this to her. So what I did was go to the family court office, and I thought, and I filled out the paperwork, and I said, let me wait. I came home, and I missed that visit.
Your visitation starts at 3 p.m., is that right?
Yes.
When is family court office open?
I think 9. I don't think that was when the messages were sent.
It mattered more to you to be in the family court office than it was to actually exercise visitation that you claim that you have 100% of the time, is that right?
It mattered that as of the past few months, Ash was showing symptoms that were extremely alarming, especially a mental breakdown on July 28th, where she, in front of Mrs. house, because she had consistently kept from seeing me, and I felt like I had to do something, and I had no intention of actually moving forward with litigation. In fact, I did not file that day, and I asked, please, just give me makeup dates. I don't want to litigate with you.
We are going to be rolling to exhibit.
Yes, please.
Mr. Passer, can you please bring up exhibit 38? This is a tape from October 4, 2023. I'll blame on, I'll give you a 3, 2, 1 on it. Okay, 3, 2, 1.
Sorry, don't you mommy did that, she shouldn't be hanging up on you or behaving that way and making it while you're crying and upset. But, yeah, that's clearly abusive. I'm just showing that to Child Protective Services. This is for you, Ashley. That and a number of other videos. I've already reported you this yesterday, and we're moving forward. You're psychologically abusing our child. Just talking parents is for you. No, you're not going to show the video. I don't know who the hell you think you are. But you're just doing it out in the open now. It's disgusting. You're disgusting. Show this to your judge. Show this wherever you want. I'll show this to any judge or whomever. You need serious grief counseling. I'm gonna get back to work on all this motion for contempt and proposing visitation. Among other things. Like, you zeroed out the book thrown at you. You're a disgusting human being. Like, that poor little girl, like, when she's crying, she's like, you just don't care, do you? That doesn't bother you. You think she's your property. You're gonna send her to school like that.
Does that remind you what actually took place on October 3 and October 4?
On October, I remember what took place on October 4th. I don't remember sending that message with those words. I have reviewed those words, and I've noticed that most of the violations that you mentioned have been single messages like that, where I was just impulsively not containing my ability to deal with the fact that I'm not seeing my daughter and I'm trying to do something.
Sir, you could have seen her the day before, and you chose not to. Isn't that right?
That's the one day the entire summer, not including the days that were left and not giving me makeup days, multiple times, including right before mental breakdown and right after mental breakdown, and in which on August 14th, where when I spoke to her and I saw incredibly troubling signs of emotional abuse, and she was describing how she'd been pulled out of all of her activities, and how I was like, wait, I'll talk to your mom about it. And your client said, no, file a motion, and just didn't seem to care at all about just how that was one of the most disturbing things I'd seen as a parent, how it was just her voice was breaking and she was breaking apart into tears. So yeah, it was starting to get to me, and I wasn't handling it well.
So you're talking about some events in
Your client
August.
laughs at that right now, but
No,
it's
no,
not
no.
a laughing matter.
Do you think she's laughing, sir?
Yeah, she just snickered at me, and that's not a laughing matter. Oh,
Sir, don't address the plaintiff directly,
No.
okay?
sorry.
Are you attempting to blame your behavior in the beginning of October on events that took place on October 14th?
I don't justify any of this language. I don't, it is reprehensible. I am sitting here.
Then why do you
taking
continue doing
responsibility.
it? I've heard how reprehensible it is over and over and over again, and there is just a litany of examples. You claim to be ashamed of this, and yet nothing changes. Why not?
The language has not changed in 8.5 months. I would like to see one example. The nasty, foul language has changed.
Sir,
Has there been foul language in 8.5 months? I don't think so.
you're right, you've never cursed at my client in the last 8 months, have you? Isn't it true you have cursed at her a number of times, isn't that right?
I think you literally have need to go back to 2021 or 2020 for your biggest example, so you can use the height of the pandemic, but I've been working on my language.
Sir,
I'm not saying I'm perfect.
which do you think is
sir,
worse? Which do you think is worse?
And I just,
Using an anti-Semitic slur, or looking your daughter in the eye and telling her your mommy lies to the judge? Which is worse?
I'm sorry, please repeat that question.
Which is worse, using an anti-Semitic slur to my client, or looking your daughter in the eye and saying your mommy lies to the judges?
I think those are oranges and apples, and neither of those can be compared to the other in terms of what they indicate or when they were said or why.
If you could only stop one of them, which one would you stop?
I would stop both of them.
No. If you could only stop one of them, which one would you stop?
If I could only stop an anti-Semitic slur or telling my daughter things I shouldn't be telling her, I think that's a loaded question, and I think you're welcome to take my lack of response to you, sir, as whatever you wish.
The reason why you won't answer that question is because you understand that even if you may have stopped using a K word or other slurs, that the behavioral violations are just as serious and significant. Isn't that right?
I remind you that I have a mezuzah on my door, and I'm the one fighting for her to stay in a Jewish school. Secondly, don't speak for my mindset, sir. I
Sir,
think I can speak for
I'm
myself.
asking you whether or not it's true. Isn't it true? The reason why you won't give an answer is because you consider them both to be of equal seriousness and significance.
I just said
That statements to your daughter in that fashion are just as serious and significant as statements to my client using anti-Semitic
I
slurs.
think the words I said was oranges and apples, and I think you're the one who's been fighting and making false statements to the court about why you should have been pulled out of her Jewish school, but that I fought to keep her in.
Okay, sir? That you are, do you claim that you've improved?
I don't say I've 100% improved, but compared to like 2023, that year, which is just when I saw the OSC, that's the reason I came in and said, took admonishment from the court, like, this is horrible, I agree. Compared to then to now, the 8.5, 3/4 of a year, and you look at the number of actual violations, I think there's 3 or 4. And except for that one incident, which I think there's like 7 or 12 in that one incident, and I even stated in the status report, there's one date and of uncontested violations that I take full responsibility for. And since then, there's been that one video and mail for it. But I think compared to like the litany of me just not being able to control my responses in 2023, absolutely.
Sir,
are we pretending
when
that-
did you finish your anger management class on June 19th?
On June 19th?
What time of day?
I don't recall. I remember I've been taking it the past few days. I was trying to create a custom GPT to create the anger journal. But yeah, I just remember I finally finished the 16 hours, and I was trying to. It says the main thing about it is using an anger journal. It's kind of convoluted, so I thought, okay, try to create a custom GPT that creates an anger journal, so you can compare in real time every day. You have these.
So you were really focused on it this time, right? On trying to control your anger, is that right?
I mean, this is something that a class that was recommended, and I took it.
Yes or no? You were really focused on trying to control your anger on June 19, 2024, is that right?
I was reading on how to try to manage my anger, yes.
Mr. Pastor, can you please open Exhibit 134? It's been admitted into evidence. If you actually would want to open it up, it's actually before you. No, I don't think 134 is before you. It was a late ad. We scroll to PDF page 4, Bates label 018169. And towards the bottom, can you zoom in so that the witness can see the communications? 11:04 a.m., 2 days ago, June 19, 2024, you state to my client, parenting coordinator, this was tabled as a possibility just like the litigation you have aggressively and perjuriously pursued. You told that to my client, right?
I sent that message, yes.
That was a violation of behavior, wasn't it?
Perjuriously, I don't see that as a violation.
Accusing my client of committing a crime isn't a violation?
I think.
Objection as to legal conclusion.
I'm asking you to understand.
You're free to say, I don't think this has been asked, or when you use that word, because you've used it regularly, what do you mean?
There's a specific action that happened after our first hearing in
Just what's your definition of that word?
Submitting false testimony to the court about actions. And there was a motion claimed about me showing up, picking up my daughter on drugs, and using that as a basis to kind of forego this mediation to prevent trial by Judge Duckworth, I believe. And there was audio evidence that as soon as my counsel endorsement withdrew, was objected to because we discovered the mission to get it, but it's proved that I was having drugs, that there was a calm exchange, and that we were both working in the car seat together. There's a motion filed about this issue after our first hearing in November about how the claim, and it had audio evidence showing that there was perjury committed, and there was actually a settlement offered based off of that perjury. But that was when I was switching counsel, and then I agreed to be drug tested. Nothing showed up. Nothing cared.
Just asking for the definition. Thank
Yep.
you.
But you certainly understood that the accusation was you're accusing my client of committing a crime, right?
Again, objection as to legal conclusion.
Just understand.
He can answer as to what he is asking for.
I was referring to that incident, and I believe that was a crime, yes, sir.
Okay. And that was how many months before?
That was the beginning of the litigation process, I'm trying to remember, November or December.
So in June 19, 2 days before we're about to have this contempt trial, you were still triggered by what you believe to have been a false statement made in November of 2023?
I believe I'm saying parenting coordinator. At the first hearing, we stated we wanted a parenting coordinator, and you refused. You said no. You fought against it tooth and nail, and I think you said absurd things during the hearing. And I can go into them, but they were definitely perjurious.
That's fine.
Anyway.
Council, I'll give the time
Yeah,
warning,
that's
we're at 4:40.
Yeah, I've got two more, and we'll be done for the day. Mr. Pastor, can we get Exhibit 43 up, please? This is a Talking Parents recording from October 15, 2023. The motion of order show cause was on October 11. The motion, misfiling of her order show cause, or motion for an order show cause was filed on October 11, 2023, correct?
Sorry, October 11th, that's
Yep.
correct.
Okay,
I
so
believe so.
with that fresh in your mind, you had this exchange with at approximately 5 o'clock, 5:15 in the evening, right?
I don't see the timestamp, I just see the video.
Okay. Well, you're eating dinner, right? Do you remember where you were on October 15, 2023?
I remember this absurdity, yes, please go ahead.
Excuse me. Did you say you remember this absurdity?
When you played it in quote the first time, please continue.
She's not your parent.
Okay. Well, sorry. Can we just start again, Andrew?
She's not your parent. I'm sorry. If she wants to register as a legal guardian, she can. If she tries to outright me, I'm gonna send her a cease and desist. Full stop. She's already tried to outright me once in a public crossing. I'm not joking with her. She's not a parent. I'm the parent. She's not mentioned in the custody order. She better watch herself.
She is that right?
She's a criminal. Straight up.
Sir, redirecting you to my question. Chi Warner is babysitter, right?
Never approved by joint custody, dangerous to my daughter, criminal, brought up multiple times. She should not be allowed near children. A supervisor has noted my own child, and I have a recording of it if you'd like to be produced later for the court, that talking about verbal abuse that she engaged in recently with my child. She should not be near my child. She has been engaged.
Your Honor,
woman should not be near
move to strike is not responsive.
Just answer the question, sir.
Chi Warner is, and at this time was, his babysitter, right?
Unauthorized with joint custody, yes.
Okay. These communications also constitute violation of behavior order, don't they?
Speaking to a person who's psychologically abusing my child and telling her to watch herself.
Where did you see Chi in this video,
I
sir?
heard her on the side.
Okay.
You can hear her. You want to play it again?
Are you telling this court that you were talking to Chi Warner at this time?
That I wanted her to hear. It's like she needs to behave herself.
That is different, sir. Do you believe that you were speaking to Chi Warner when you said these words that we just watched?
Yeah, I don't think Act understands the terms applying for custody. I believe I was speaking to this woman who has shown multiple times in multiple different recordings that have been submitted to counsel and to you multiple times. And I spoke about only. I spoke to plaintiff about only last week. Consistent verbal and emotional abuse of my child. And against
Redirecting you to my question, okay, which was, you were speaking to your daughter when you said these things, not to Chi Warner, right?
That's correct.
Okay, and yet, despite the fact that you were speaking to your 4-year-old daughter, you brought up the custody order, right?
I believe I said if she wants to file for custody, she is welcome to do so. That's not bringing up the custody order or court proceedings.
Isn't it true your statement was she's not mentioned in the custody order?
She is not.
Isn't it true? That was your statement, sir.
I believe so.
Okay, do you think that was appropriate?
I don't think that was appropriate. I don't think she is party to the behavior order. I think she is party to perhaps a protective order after all of this. If anything, this person should not be near my child.
So you acknowledge that that was an inappropriate communication that you had with your daughter at this time?
I think I was trying to show my daughter that I am going to stand up for her around this woman who's psychologically abusing her.
So are you proud of this communication, sir?
No, I'm not proud of it. I'm sad that that woman's has been and is continued to be allowed near my child.
But that's not the appropriate way you bring it up, right?
No, it's not. That's
Okay.
absolutely not appropriate. I
Right.
was frustrated, and I was definitely not handling the fact that my ability to choose caretakers for my own child was being not acknowledged and is leading to emotional.
So once again, it's someone else's fault
No, it's
for
my
your
fault.
behavior.
It's my fault. I need to shut up and handle things better. That's not okay, but there's a lot happening at once, again and again, the summer of last year, and I wish I
That was
had better impulse control.
that was
I did
4
not.
days after the motion for show cause was filed by me.
Yes.
Okay, now it's going to fast forward 3 more days to another communication you had with your child. This is going to be Exhibit 44. This is from October 18, 2023.
Shanti, I'll tell you the rest of it. Okay. You don't want to hear the rest of it? Okay. Sorry you were coached. You were fine. Just
Okay, that's inappropriate. She said
So
no.
why don't you hang up and I can present this to the court too? And then when I tell the whole story and
Stop.
I'll present the video of that to the court.
Focus on.
I am trying, but you're trying to cut me off from her. When you take over, I have to focus on you. So remove yourself from our conversation.
There were 2 violations of the behavior order.
I think you're
On-
missing a video.
Sir,
I think you're missing a video there. The one that led up to that, because there was a cutoff and continuation. I was reading a little red writing. that-
sir, I would like to ask you some questions. There were 2 violations of the behavior order by you in that very short clip, weren't there?
In the responses to the first one, yes. But they were.
No, I'm referring to
violations.
just now. What we saw, Exhibit 44, your communications to your daughter while my client was in the background of the kitchen. Right? You violated the
Yes,
behavior twice
I
then.
definitely should not have reacted that way to the video that you're not showing.
Sir, what's the justification for telling your daughter you've been coached?
The justification, there's no justification.
And yet you still do it then.
This is in October.
October 18, 2023, 7 days after the motion for an order to show cause has been filed by my client.
Sir, we're almost in October again now, in 2024. You're saying I'm
It's
still doing
June,
this?
sir.
June, okay.
It's
And
not
for 3
October.
months- So 3/4 of a year later, you're saying I'm still doing that?
Sir, we just saw 6 weeks ago, you told that my client was lying to judges, and that was the reason you weren't seeing her.
And that is completely inappropriate.
So yes, there are things that are happening, continuing to today,
You're saying
about this action that you're communicating.
incident in May.
Is there a question?
Don't you agree that there has been a consistent pattern of,
I agree that
don't
there's
you
screen-
agree that there's been a consistent pattern of you saying inappropriate things, including but not limited to, multiple times where you involve her or discuss issues of court proceedings with her?
I would say that is correct.
Okay.
Yes,
And that most recent example that we have thus far is the May 4, 2024 communication, right?
after a very long period, yes. After I noticed that that needs to stop, yes, that was just the other time.
But what was the time before that?
I would say it was that time during that topic exchange, and before that, I can't remember.
What about Christmas?
Christmas,
Isn't it true you brought up court proceedings on Christmas night, December 25, 2023, after my client invited you to have dinner at a restaurant? At the conclusion of that evening, you brought up court proceedings in front of her.
no,
You deny it?
absolutely.
Okay. Isn't it true that 1 week before that, December
I'm
18th,
sorry, where's the tape? You've been playing tapes? There's no
We're-
tape
we're-
for this?
Sir,
we're running on it, and I have the opportunity to confront you with
You're
the
screaming at me, at least. show
I'm
me.
certainly not screaming at you,
Of
sir.
course, yeah. Okay. Please-
Sir, do you
sorry.
consider what I'm the tone of my voice to be screaming?
You seem to consider when I have that tone to be
Sir,
inappropriate, so please
sir.
go ahead.
just answer the question.
Isn't it true on December 18, 2023, that you were at a doctor's office with my client because she was sick at that time?
Yes, Your Honor.
And isn't it true that during the waiting for the doctor to arrive and examine, you had brought up additional matters of court proceedings with my client in front of
Incorrect.
That's also false?
Your client brought it up, and I sent the video to Attorney Page yesterday when we talked about it, because we reviewed the messages. Your client brought up something about the birth certificate when I was trying to leave. I was trying to leave because there was conflict. Your turn, and I said, listen, I didn't choose this because I was trying to leave to get evidence of the fact that what you claimed to Judge Duckworth was false, that I did take the drug test, going to Quest Diagnostics. I didn't want to talk to her about that. She said, so I was trying to just walk out of the door. This is on video, excuse me. And she said, oh, I said, I didn't choose this. She said, you didn't choose to be a father? I said, please let me go. She was like, I was like, well, you didn't put me in the birth certificate, I guess. And she's like, well, oh, I did put you in the birth certificate. And she starts pulling it up. I was like, well, let me just go, please. And
Sir, isn't it true that you raised the issue of the birth certificate in earlier papers before December 18, 2023?
I did not. Jesse Allison posted those. And
On your behalf.
And when I confronted her about that, after the situation, as I've said, I've waived privileges. And when I confronted her about that for the next hearing, I was like, I'm told by Miss, that's not true. Why did you put that there? She goes, oh, I don't know anything about that. And then I was very upset to see her post it again in a motion about hearing, because that's not true.
But isn't it true you signed a declaration specifically stating that she was still off the birth certificate, right? This wasn't just Miss Allison writing it. You wrote it in a declaration and signed it in February 1, 2024, excuse me.
At the time, and I had no reason to believe that she was lying to me.
And it's from the declaration.
Sustained.
Finally.
Sir, isn't it true that you brought up the issue of whether, isn't it true you accused my client during that time period of leaking sealed documents in the case?
As I was trying to leave, your
It's a yes or no question.
Yes.
Okay, and we have a tape recording of this interaction, right? You said so?
Video recording?
Mm-hmm.
Absolutely.
Okay, that video recording isn't permitted by the behavior order, is it?
Actually, the behavior order says you can record video. You can record if the person is violating the behavior order, which is kind of a chicken and egg situation, isn't it? It's like, how do you know someone's going to violate the behavior order unless you're recording?
Well, it's a great point, because what we're going to see is the dichotomy between the two, because we saw two videos from January 30, 2024 that you started even before you arrived at the exchange, and then we'll see the commencement of her recording once she saw what was happening. So we will have the ability to compare and contrast what this chicken and egg problem is. But I'm going to move on, because I'm going to ask you the question, when did you decide to record that interaction on December 18, 2023?
As soon as I realized she was blocking my exit.
She was blocking your exit?
She was trying to stop me from leaving, saying, you have to stay here. And I was like, I want to go. Because I didn't want to tell her why. I didn't want to tell her that it was going to Quest Diagnostics to give proof that her attorney's claims that I had not taken the test were lies. I didn't want to create conflict. I wanted to go.
Mm-hmm.
And she was blocking my exit, so I turned on the camera. I turned on a video.
And we would know that because you produced that videotape in response to my request for production of documents, right?
I did send it to Chris Smith.
But then you followed up later and sent me an additional approximately 20 videos for which that wasn't included, was it?
I'm not sure.
Isn't it true that I then followed up in April, asking you to supplement your responses? And you didn't do so. To supplement your responses for the request for production. So you get another opportunity to add additional materials as you have them, right?
I don't recall any
Objection
communication from
form
you.
foundation.
I don't think I had counseled them.
Yeah.
I didn't know what happened.
Sustained, we're going to stop.
That's fine. We're
Yeah, we need to wrap it up so that
Yes.
you all can get everything before
Mhm.
it's supposed to leave.
and Your Honor, if there's one thing, you admit now that the birth certificate, right?
Yes, and I.
Okay, so now my next question is this. Why does the current pretrial memorandum filed on your behalf still reference that Miss isn't on the birth certificate.
Objection form foundation, he has no recipient knowledge. I had this discussion with Mr. Jimmerson as to why it's still there.
So your client wouldn't know?
He wouldn't know.
Okay.
Quite frankly, I copied it from
You
what
didn't
Jesse
write
Allison
the
wrote.
pretrial memorandum, correct? You didn't write it?
Yeah, and
You did not write it?
I did not write it.
Okay, so your counsel just said you wouldn't know. And to be clear, sir, your counsel has not started cross-examination. These videos that you referenced, whatever your counsel believes should be introduced, you'll have that opportunity. So that's why I'm trying to get you
Yep.
through
Yes, Your Honor.
plaintiff's examination.
Yes,
Okay.
sorry.
All right, so this is what we'll do. All current orders, you are excused from the stand, sir. All current orders will remain status quo. We have an additional stipulation that will need additional language, counsel, with the parameters of this communication. The most important is that the parties will not have communication with each other.
And it begins immediately, Your Honor, is that right?
Yes, and sir, this is firm admonishment, because you know now, and you testified over and over again today that you can recognize what behaviors are inappropriate directly regarding your daughter. So you are not to involve her into litigation, call mom's name, talk to people that are off camera that you believe are there through your daughter. Any of these actions, you can talk further about it with Mr. Page, that you have agreed are inappropriate, you're not to engage in, so that you can continue having appropriate conversations with your child. Not adult matters, child matters, just you and your child. Okay? Counsels, I'm sure you will confer about the language regarding
Absolutely,
the communicator. I'll just say, whomever you will select. And it's my understanding you will do that in about a couple of weeks to get that going. As far as schedule, we'll do this. I do not want to basically start over with this case around Christmas.
Mhm.
So we're going to put you on our very short waiting list. I would prefer to have either another full day or 2 half days, because Mr. Page, you've not started your case in chief, and then when we get started, Mr. Jimmerson, we'll talk about how much more time you need, because you have not started with your client, how many days this trial is going to last.
Hopefully it'll be one day, Your Honor. And I don't think I have a whole lot more with Mr. I believe a lot of the evidence speaks for itself, and I believe my client, will be succinct when she describes what happened.
Well, the idea is, I'm not one for putting people on the clock, but I will watch the time more closely the next day, because I must give Dad the same amount of time and opportunity to present his case in chief as well. So if we have 2 days for your case, that means this could end up being a 4-day trial, and we know that's very expensive for the parties. And because we do not have that amount of time back to back, because we're plugging in our super busy calendar, I will prioritize this case, I can promise you that. So the first matter that comes off, what we do, to be clear, Roxy, my assistant, wants me to say this, as soon as we have a date come up, we're sending an email jointly to councils. Please respond to the email. We only hold those dates for 24 hours, and then it's on to the next case, because unfortunately, we're packed. Summer, parents have a lot of conflicts about school and other things. So right now, it's my understanding, if we're not back before school resumes in August, the child will be attending.
That's correct, Your Honor.
And it's my understanding that's because there's no longer a spot available at Allison, but if this is a continuing issue, of course, we will continue to address that issue. So that will be a temporary order based on the fact that that is the spot that is secure for the child, to my understanding. And councils, you can continue to talk about what's going to happen regarding this birthday, that the parents typically split, and make up time, and when Dad will have some time
No,
to,
Dad will be exercising time on Sunday, Your Honor.
on the child's birthday?
Yes,
When is the trip?
there's no trip. The whole point was she'd gotten tickets with the opportunity that Mr. would come along as well. Or that there,
You don't want to go to England and see?
it's not true.
Completely categorically false. It's just
You want-
enough of this.
Okay.
I'm gonna walk out of here.
She can send it back.
My client saying that, correct me if I'm wrong, is that she said that you could fly out to England along with her. You'd have to pay for your own ticket.
Not with her. I could spend about $3,000-4,000 to go sit in a different section after missing her other, and that would be my only experience of any of her birthdays that she was born.
Okay,
took it
so
away.
she didn't wanna sit in the same row with you, but
And now, so I could fly to England and be in a different row in a Taylor Swift concert, and that's so I could be near my daughter.
so the trip isn't happening.
There will be,
And that'll be the first birthday ever.
I
since
thought
she's
that you were-
4.
no,
Okay, well then that won't be an
Yeah.
issue.
All right.
So it's my understanding, to be clear, Mr. Page, the trip that we discussed in the back is not even happening, and they will split time.
Up until this is what I thought was being forced on my client, was that he was going to have to miss his daughter's birthday.
no,
Okay.
He missed his.
no.
I mean, I've watched the videos where the child said, I really wanna go, and dad's, in the.
The trip isn't happening, so you all will split time for your, okay.
Correct, Your Honor. She'll have the morning, he'll have the afternoon. I want to emphasize how important it is that the timing is adhered to, because there's actually a lot of birthdays. I believe that my client's father is also celebrating birthday this weekend, so we've got a fairly tight schedule. So as long as everyone's on time, we're ready to go.
Cancer season in full effect.
Indeed, Judge. My stepmom had her 60th birthday yesterday, so
When are
it's,
we coming back?
she's
We'll
got
let
us
you
on
know.
the
We have to
wait
find-
list.
We have to find time because our ordinary course is Christmas, and I don't want you to wait.
We're coming
too
back
long.
before that.
So as things resolve, we do, good thing about summer, a lot of people are resolving, we'll give you that next time.
Thank you, Your Honor. I
All right,
appreciate
thank you,
all
everyone.
the
Thank you for
time from the
your
court
time.
and the staff. Thank you.